This case came to me about 2 weeks before the statute of limitations. The mother came up to me and she said that she had been referred to me if I'm an attorney in Riverside, and that she had been trying to settle the case herself for the $15,000 policy. Tim Herman was driving home about 4 in the morning in the #1 lane of the Interstate 15 freeway south of Corona. And it appears that he fell asleep and he hit the center divider and spun out, ended up sideways in the #1 lane. Good Samaritan is coming home with his wife, and he happens to see Tim Herman's car broken down. They pulled over to the side of the road, turned on their flashers. They ran across the street to help him get out of the car, and while Tim and the Good Samaritan were on the side of the road, another car driven by the defendant, Mr. Cardiel, struck his car, and they threw him over the bridge, and he ended up hitting his head. There was a lot of challenges in this case. My client has alcohol in his system, which the jury never heard. We won that in motion in limine, but that created some other challenges because to get that to be found irrelevant and 352'd out, we had to go in and say, well, we will concede that our client bears responsibility and is negligent as a result of his own actions. But our argument is he's not the only one negligent, so we were always going in there looking for a percentage of negligence against the defendant. They had a very good defense in that the defendant was actually driving at or under the speed limit at the time of this accident. The argument that we raise is in California, that's not good enough. You have to drive pursuant to the conditions that are safe for you. So even though he was at or under the speed limit, our argument was he's an older gentleman. Yes, he's driving the speed limit, but he's clearly not paying attention based upon his age, based upon the darkness, that he should have been driving slower than even the speed limit. The jury felt Tim's own actions of breaking down, his own actions of not driving off the road, his own actions of not getting out of the car and running across the road, that was the substantial factor in his own injury. Luckily, that was the straw vote, and when they sat down and really went over the evidence, they overcame that and turned around and came out, I think it was 10-2, but it was literally against us. We were that close to losing on the straw vote. My client's mom is a lawyer, and so she understood that it was a $15,000 policy and that she had a $100,000 underinsured motorist provision policy. So she never thought she would get more than that, frankly. We actually had an offer prior to trial of $2 million that we turned down because that wasn't going to be enough for Tim. For a gazillion dollars, no one would change places with Tim Herman. And once the jury understood that story, the numbers weren't actually all that difficult to get. His life is brutal and it's sad. They gave me every penny I asked for. And some jurors said that that was a compromise number. They literally wanted to give me over $100 million. My whole team is based upon the concept of, we're gonna do what's best for you like you're our family member. And that's what we did here. You know, I love the Orange County trial. I remember that story about how someone lost something that was so important to them and they actually went out of their way, they found it, they gave it back to them, didn't ask for rewards, did nothing. And then the other person, give me something, the other person actually then came up and said, why don't you hold on to this so that you can survive the year based upon your post-traumatic stress? Do you remember that story?
Of course, I think little children talk about it today.
It's amazing what this organization is about.